Hi, I'm Jennifer Hemingway, and this is my report on one issue of student rights in conflict in our schools. In a society where interests conflict, there can be no absolutes. So the conflict in question is this year, as part of our graduation celebrations, a senior student objected to being required to rehearse and subsequently attend a baccalaureate service the Wednesday before his graduation. It was, in fact, the last day of school for seniors. He felt he could not be forced to participate in a church service. He was told that our school has always held a baccalaureate, that his teachers, his class sponsors, and school staff had worked hard to create the event for him and his peers, and that he did have to participate, as the rehearsal at the time of his question was during school hours, when he is required to be in attendance or excused by a parent. Of note is both the rehearsal itself and the service were held off campus in a church sanctuary. So substantial case law and Department of Education, federal Department of Education guidance exist to support the student's assertion. Starting in 1962 with Engel versus Vitale, the court overturned a New York State requirement for daily classroom invocation, stating it is no part of the business of government to impose official prayers for any group of the American people to recite as part of a religious program carried on by government. Public schools being considered government institutions. 1987, Santa Fe Independent School District versus Doe. The court held that the district's policy permitting student-led, student-initiated prayer at football games violated the Establishment Clause. The football game prayers were public speech authorized by a government policy and taking place on government property at government-sponsored school-related events. Thus, the school district's policy involved both perceived and actual government endorsement of the delivery of prayer at an important school event. Now, also 1987, Bennett versus Livermore Unified School District, the court upheld that religious invocations at high school graduation ceremonies violate the Constitution. Large districts across the country immediately began eliminating baccalaureate services and opening prayers. But the practice of having both of those things continues in smaller and more rural conservative districts to this day. Lee versus Weissman, 1992. Whether the school district's practice of inviting clergy to give a non-sectarian invocation and benediction at graduation violates the Establishment Clause. And it was determined that it's coercement. At a minimum, the Constitution guarantees that government may not coerce anyone to support or participate in religion or its exercise or otherwise act in a way which establishes a state religion or a religious faith or any intent to do so. The undeniable fact is that the school district's supervision and control of a high school graduation ceremony places public pressure as well as peer pressure on attending students to stand as a group or at least maintain respectful silence during the invocation and benediction. All of these refer to the Establishment Clause under the First Amendment. Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. So what does that mean? What is the Establishment Clause? When does government activity breach the wall of separation between church and state? So under the Establishment Clause of the First Amendment, and in line with the preceding Supreme Court rulings, public schools may not impose prayer or other religious practices on students, even if students are not required to participate. There's still that coercion. Thank you. The First Religion Clause says government and its agencies are prohibited from establishing or requiring religion, including official attempts to impose or instill beliefs in students. Public school officials are therefore prohibited from directing, favoring, or even sponsoring religious activity. likewise, under the free exercise clause of the same amendment, and in line with the same variety of Supreme Court rulings, public schools may not prevent students from expressing or sharing their own personal religious beliefs, as long as their doing so doesn't disrupt school. So, conclusion, baccalaureate services in public schools are prohibited even if students are not required to attend. There's a guidance policy that is issued by the government, by the Federal Department of Education. Since 1995, it's sent to every public school superintendent. It's required under the Elementary and Secondary Education Act of 1965, which amended became the Every Student Succeeds Act. So it's sent to all public elementary and secondary schools, state education agencies, and local education authorities. And it says basically what we've discussed here. Specifically, Article H says the prayer graduation cannot happen, and Article I is specific to baccalaureate services. School officials may not mandate or organize religious ceremonies. So they can make their facilities available to anyone. If they make them available to one group, they have to make them available to everyone. But school personnel cannot in any official capacity. So senior class sponsors cannot speak as senior class sponsors. Administration materials cannot be printed on school equipment, etc. So the Establishment Clause prohibits baccalaureate services, and my student was in fact correct. And these are my references. Thank you.